Appellate District is now in session. Acting Presiding Justice, the Honorable Patricia Bowman-Nuku, Associate Justice, the Honorable Allison M. Danner, and Associate Justice, the Honorable Charles E. Wilson.
Good afternoon, and please be seated. I will call the calendar this afternoon case by case, and we will have a panel change on the very last case. When I call your case, please do state your appearance and provide a time estimate for the court. We have read your briefs, we have read the issues that you bring before us, and it would be helpful if you went right to those issues that you think would be most helpful to the court. It's so nice to have people in court. This morning, the only people in court were the three justices, the clerk, our IT person, and the deputy. So welcome to the 6th District Court of Appeal. The first matter on calendar is Lee versus Hailing You et al. We'll ask appellate counsel to state your appearance first, please.
Yes.
And feel free to take off your masks at the table and during
Can I
argument.
take it off?
Yes, during argument and at the table, that's fine.
Okay, thank you. Good morning, Your Honor. This is Counsel Zheng Liu for appellants. I request 10 minutes for initial argument and then 5 minutes for rebuttal.
Thank you.
Good afternoon, Your Honor. Rohit Chabra on behalf of respondent Ms. Lee, and I'm estimating around 4 minutes unless the court has questions.
Thank you very much. Counsel, you may begin when you're ready, please.
Yes, sir. May it please court, Your Honor, this dispute is a bitter dispute, as you can see from the briefs, but this appeal rather presents a simple question of law. Under California's motion to compare arbitration jurisprudence, there's a 3-step analysis that has to be applied to decide every single motion to compare arbitration. The first step of that analysis is that the moving party moving to compare arbitration must meet his or her burden of production to show there's a prima facie agreement that concerns arbitration. And then the burden shifts to the party resisting arbitration. That party have 2 choices. That party can present no evidence at all, or that party can produce evidence to show that somehow the agreement does not apply. If the other party, the party resisting arbitration, does not produce any evidence, then the analysis ends. Then the moving party meets her burden to compare arbitration. Then the case must be compared to arbitration. But if the other party meets her burden of production in the second step, then the burden of proof kicks in, and then the burden of proof basically will be applied to the moving party to prove beyond a preponderance of the evidence that the dispute must be compared to arbitration. So that's the 3-step analysis that has to be applied in